In view of the above, this court is of the opinion that no relief is entitled to by the petition. Accordingly, petition is dismissed. At this stage, learned counsel for the petitioner submitted that the pension and other post-retirement benefits have not been released to the petitioner. It is accordingly directed that the pension of the petitioner may be released in accordance with law. However, the said direction is subject to the liberty granted to the petitioner to make further inquiry into the aspect of allegation of forgery in the documents produced by the petitioner and even to institute appropriate criminal case if deemed necessary.
54, 56.
The present employer, namely the local urban bodies where the petitioners services have been handed over, are accordingly directed to immediately release the pending salaries to the petitioners working in various municipal boards and also to ensure payment of current salaries on time. For the said purpose, municipal boards can take necessary financial assistance from the state government as grants in aid in view of the constitutional provision as mentioned above. And in that said respect, state government is directed to consider and grant such financial aid in accordance with law. The state government in the Housing and Urban Affairs Department as well as the Finance Department are also directed to play an active role for an overall and lasting solution on the issue of payment of salaries. Said departments may also cause inquiry into the aspect of shortfall of collection of revenue from the water supply schemes and depending on the outcome of the same, take necessary steps to redress the issue, including taking penal action against any erring person and including any of the petitioners is found to be at fault. Findings of the committee constituted by order dated so-and-so of this court in these petitions as forwarded by so-and-so may also be taken into account. Writ petition stands disposed of. The order of the prayer for regularization we have considered and we have said that there cannot be, mandamus cannot be passed.
Obliged.
I plead the lordship. I have filed a review petition, my lord, and which was listed on 24/6/2024, but not read. The matter may be listed on.
When? Wednesday.
When?
Review against what order? Of this court's order?
Yes.
What is the review you are seeking?
A review for regularization, my lord, and pay the earlier salary.
No, review for what?
Review for correction of, review the order passed by this court.
Understood. What is the ground? What is the error apparent?
My lord, that the case was, this court was directed to pay the salary from the managing committee, but the petitioner was working for last 26 years. And
okay, Wednesday we'll consider, we'll see. Wednesday. Okay.
May I please the lordship, my lord, I pray for listing of a matter, admission matter on next Friday, my lord. The matter pertains to, in this matter, my lord, the private respondent, his promotion, there is an interim order due to which the promotion of the private respondent to the post of PSP is being kept in abeyance, my lord. So for admission hearing on Friday, on last
Matter of which year?
matter of 2021, my lord.
Okay, Friday.
Obliged, my lord.
May I please? I wish to mention for listing on 29 on Monday
Listing of?
for admission.
Matter of which year?
24.
24. Why? What is the urgency?
It was
Out of,
last listed on 4th April.
what is the urgency? Out of turn
My lord, the
listing.
petitioner is suspended without following procedure, and the petitioner has two children without.
Suspended, are you getting subsistence allowance or not?
My lord,
Are you getting subsistence allowance or not?
no, my lord.
You're not getting?
No.
Not on Monday, on Friday next.
Obliged, my lord.
May I please the lord? Item number 60, lordship, and motion.
Item number
60, lordship.
60.
Yes, sir. Supplementary text.
Yes.
This matter may come on next week. Lord.
Motion. Okay.
Motion, lord.
That two for us lordship. They have filed an they have filed it.
No, no,
Forwarded slide on the appropriate authority for disposal.
Appeal regarding what?
Dismissal from service, lordship.
Okay, Wednesday, you point this out to the court on the next date. Madam, you take instructions on this aspect. On the prayer of Miss S. Kanungo, learned counsel for the petitioner. Matter is adjourned to be listed on Wednesday next.
May I please?
Yes.
my lord, I have to mention one requisition of 2019 matter. Matter is pertaining to pension, my lord. The husband is expired, my lord.
Okay,
On any
Wednesday.
convenient date.
Wednesday.
May I please, your lord? The admission matter, my lord. My lord, taken a removal of service. That is taken on 30th,
Matter which year?
2023.
23, not out of turn listing.
May I please, sir? Therefore, listing a pending.
What is the stage? Admission,
Admission?
not yet admitted,
Not yet admitted.
not at this stage. We'll see. Okay,
Therefore, listing a pending motion matter. Lord.
motion.
Motion.
Okay, we'll have it on Wednesday.
May I please, Lord?
May I please, Lord? Lordship, I beg to mention item number 40, my lord.
40.
Yes, my lord, daily lift item 40.
Yes.
My lord, I pray for 2 weeks time, my lord. On last occasion, I was directed to file an additional affidavit. My lord, I pray for 2 weeks time, my lord.
You have not filed.
Yes, ma'am.
You have not been able to file it till now.
Yes, my lord. I requested for some documents from the.
No, understood. You need further time to file.
Yes, my lord. 2 weeks. My lord, if the matter can be taken on 16, my lord.
We'll grant you 2 weeks time. On a request made by the petitioner in person, matter is adjourned by 2 weeks to enable filing of additional affidavit.
If date
Have,
could,
have you informed the PNB?
Hello?
Have you informed the council for the PNB?
I will inform the.
Have
council.
you informed?
No, my lord.
Don't make a mention without informing. You're supposed to inform first, then make a mention. Don't write. Yes. Let the matter reach. We'll grant you the time, but in their presence. Okay.
May I please, Lordship? My lord, in connection with item number 59, Lordship, we have filed an additional affidavit.
15. Yes, bring it.
May I please, your lord? Lord, I have to mention for listing of the dispute.
What stage?
Motion.
Motion, yes, Wednesday.
Obliged.
Lordship, I pay for listing of 3 matters tagged together in 2023 matter for they are not getting pensionary benefit after 5 years.
Pension, okay, Friday next. Pension matters.
May it please, your lord. I'd like to mention for listing for pending petition of 2024 law regarding non-payment of retirement benefits in area.
Okay, Friday next. Retirement benefits.
Lordship, in item number 43, may I call for record?
Yes.
We have
Item 57, for withdrawal.
May it please the lordship, my lord. Now, here the petitioner already retired, my lord.
You don't want to proceed.
Yes, my lord.
Heard Sri BK Das, learned counsel. No, Sri BK Das,
My lord.
learned counsel for the petitioner submits that due to change of circumstances, comma, the petitioner does not want to proceed further with this writ petition. Your name?
I call it.
I Kulita for Peachy.
For his PhD project.
Peachy.
Yes.
Sri I Kulita, learned counsel is present for the public health engineering department and finance. Anybody? Finance department? Who's there in the court?
Solia was
H.
there.
Olia.
Yes, Solia was there.
H. Olia, finance department. No? Writ petition is accordingly dismissed
My lord,
for
interim order may be-
non-prosecution.
Interim order may be vacated, my lord.
Interim order passed and interim order, if any, stands vacated.
Same prayer in the second item also, my lord. Same, my lord.
Same.
It was in regard to suspension matter.
Okay.
Obliged.
58. Same. Huh? I Kulita. And it was, is
There
there
is
any
no interim in the second one, my lord.
separate orders?
Obliged.
Item 1.
In this matter, I am appearing on behalf of R. Chaudhary. Due to some certain difficulty.
On behalf of Mr.
R.
Ari Chaudhary. Okay.
Last occasion, your lordship, this honorable court directed, there was an instruction produced by the opposite party.
Yes, any
Yes.
development?
After the, my lord, financial sanction done, my lord. Now we have forwarded to the Accountant General, my.
Let us issue a short notice and we take
Yes,
this
that can
into, okay. You're Mira,
Yes, sir.
you're not there.
Not there.
K Mira,
Came here.
heard Sri K Mira, learned counsel, appearing on instruction of Sri R. A. Chaudhary, learned counsel for the petitioner. Full stop. The matter pertains to a claim for release of arrear salaries. Full stop. On the last occasion, comma, the learned standing counsel of the PNRD department, Sri Datta, had produced a copy of the instructions to show that the budget proposal was raised, full stop, today, comma, Sri Datta, the learned standing counsel, has placed before this court a copy of the latest instructions dated 13/6/2024, whereby the amount has been sanctioned, full stop. In view of the above, we will not issue notice unnecessarily. In view of the above, matter is adjourned by 4 weeks, on which date the up-to-date instructions be taken by both the council for the parties.
Okay.
Okay, we'll close it on the next date.
Tablet.
Item 2, Mr. Chetri. None appears for the petitioner on call. Even on the last occasion, that is 26/6/2024, there was no representation on behalf of the petitioner. Full stop, para. In the interest of justice, matter is adjourned adjourned to give a final opportunity to the petitioner. Full stop, list on Wednesday next. Full stop, it is made clear that in case of further default, comma, appropriate orders would be passed.
May please, sir. Order is page 11, my lord, and operative person page 15, sir. Page 15, last paragraph.
Page 15.
16, last paragraph. In view of above.
Heard, Sri H.R. Ahmed, learned counsel for the petitioner, who by means of this application has complained about willful and deliberate violation of the order dated 15/12/2023 passed in WPC 7218 of 2023. Full stop. The learned counsel has also referred to the communication dated 21/12/2023, by which the said order was brought to the notice of the respondent. इसके बाद issue notice. Steps within 3 working days, registered post AD. Take steps by registered post AD.
My lord.
Item 4.
May it please your lordship. The petitioner here is being aggrieved by for non-compliance of the order dated 8/5/2024 in the PPC 7201 2022. The relevant portion is Annexure 1, page 16, para 12.
Please read.
Page 16, 1
Please
6.
read. Minimum pay scale,
Yes, my lord.
not given.
Not yet. So the petitioner, they have communicated with the department. No reply has been made by the respondent.
Eight five. Don't you think you're too early to come to the court?
Kalin action notice.
8-5, the courts had passed order.
Yes, my lord.
Okay, 2 months have passed, but don't you think that's too early for a contempt matter? It is to be deliberate and willful. You don't even give them adequate time.
At the earliest, it's in the
Earliest?
office, like it.
Will it be reasonable on your part to allege contempt?
Kalin issue notice.
We are not issuing notice at this stage. You should be reasonable, madam. There are hundreds of cases. It has to be willful and deliberate. Give them some time, at least 4 months' time. You don't even give them 2 months' time.
I pray that your lordship may issue notice at this time.
We are not issuing notice at this stage. This will come after a month. In this petition alleging contempt, this court has noticed that the order in question is 8/5/2024, whereby a direction was given to give benefit of minimum scale of pay to the petitioners who had rendered their services as mastered worker. Full stop. In the opinion of this court, adequate time for such compliance has not been given, as a contempt will lie only for willful and deliberate disobedience. Full stop. Para. In view of the above, matter is adjourned to be listed after a month.
Okay.
Please, the lordship. This is the contempt petition, lordship. Order of non-compliance is at Annexure A, lordship.
Page?
From page 12 to 16. Relevant portion is at page 16, lordship. The para that starts with situated. Dear lordship, the respondents were directed to settle the admitted salary for the period spanning from 21/5/2009 to 31 January.
What is your name?
My name is Bibi Kakot.
Harshri Bibi Kakoti, huh? Same, huh? Non-compliance. Then representation at 29/1/2024. देख लीजिए, huh? Order dated 12/1/2024 in WPC 133 of 2011. Okay? Yes. Take steps. Registered post within 3 days.
Obliged.
May I please, Your Honor? Last occasion, Honorable Court has called for instruction from respondent authority, Lord.
Forest Department.
Forest Department, Lord.
Yes.
Lordship, we are seeking some time to receive the instruction.
What is the matter about?
Lordship.
What is the matter about?
Matter is, I was appointed as a casual labor. Latest list, respondent authority has not enlisted my name, Lordship. For fixed pay, for fixed pay, Lordship. Lordship, kindly stay the latest list, Lordship.
Will not stay. How will
Because
you
process
get?
is going on, Lordship.
How will you get the benefit if the consideration of others are stayed? If you make out a case, we'll direct for your consideration.
Lordship.
B. Khaklari.
B. Khaklari,
Harshri B. Khaklari, learned counsel for thee. petitioner. Full stop. The petitioner was appointed as a casual labor in the year 2006 in the forest department. Full stop. The grievance of the petitioner is that even after working for a long period of time, comma, in the office order dated 10/1/2024, whereby a list has been prepared, comma, the name of the petitioner is not found in the said list. Full stop. Para. Let notice be issued, returnable on
Sorted, Lordship.
returnable on 14th of August. Protocol for all
Forest Department.
or for all?
Sure.
I protocol for all the standing counsel forest department for all the respondents. Huh? That extra copies within 3 working days. Give extra copies.
Give a blast, Lord.
After for a timing.
On behalf of Mr. Goswami,
Yes.
R. Goswami.
Yes.
You'll be appearing or Mr. Fukan will be appearing? You call him also, passing over for the time being?
Lordship is not present.
You will take instructions, you will take notice. It's for motion. We'll see. Are you seeking adjournment or what?
Yes, Lord.
No, Lordship, actually, I have an objection. Last day, they already adjourned.
Okay,
Yes,
we'll have
Lordship,
it,
but,
have it after some time. Okay.
Lordship,
Call Mr.
today-
Goswami, we'll have it after some
Today is not present, Lord.
Okay, we'll see what is the matter. If we find that it's a matter for adjournment, we'll grant adjournment. It is for motion only.
May please, Lordship. Matter
Yeah.
pertains to non-release of gratuity amount. Gratuity amount is admitted amount, Lordship.
CGC,
This is Hindustan paper, Nagaon paper mill, Lordship.
Nagaon paper mill.
Yes, Lordship. The
Nagaon paper mill has gone for liquidation long time
liquidation,
back.
Lordship. I have made the liquidatory party, Lord. Page number 20, annex 2, Lordship. This is the admitted gratuity amount. Lord. Page number 20, Lordship.
Hindustan Paper Corporation has gone under liquidation.
Yes, Lord. I have made the
But how? Who
respondent-
will take notice for 2 and 3? 2 and 3, is it in existence?
They are in existence, Lordship.
Where?
2 and 3, Lordship. Nagaon paper mill.
The
Because
company has gone on liquidation. Where is it? How is it existing? It's been liquidated.
I have made the liquidator also party.
That is okay, but who will take
Liquidation process has not been over till date. Lord.
Where have you made this statement?
No, that statement I have not made, Lordship.
So how do you know it's not over?
Because Assam Industrial Development Corporation, there is some consultation is going on with government of Assam Industrial Development Corporation and Hindustan Paper Corporation Limited. Accordingly, the government Assam has agreed to certain.
Okay, heard Sri A.D. Chaudhary,
Lordship.
Planet Council for the petitioner. Full stop. It is the case of the petitioner that he was an employee of the Hindustan Paper Mill, of the Nagaon Paper Mill under the Hindustan Paper Corporation Limited, which has gone on liquidation. Full stop. When did you retire?
31st of December 2016. Lord.
The petitioner had retired from service on 31/12/2016. Full stop. The grievance of the petitioner is non-payment of the non-release of the gratuity amount. Full stop. Let notice be issued. Returnable by 4 weeks. Union of India. Madam. LDB. RKD, huh? LDB. On behalf of RKD Chaudhary, Deputy SGA. 4-1. Let steps, let extra copy, huh? One, let's go on. Let steps be taken for service of notice for 2, 3, and 4 by registered post with AD. Steps within 3 working days.
Lordship, pendency shall not be barred to release.
Pendency, pendency shall not be a bar for consideration and release of the amount in question.
Obliged, Lordship.
Item 9.
Please, your Lordship. Lordship, we have instructions from the petitioner to withdraw the matter with liberty.
Okay, what is your name, madam?
P. Bangsheri.
D.
Bangsheri.
Bongsheri. D.R. Bongsheri.
Yes.
Miss D.R. Bongsheri, learned counsel for the petitioner, submits that instructions have been given for withdrawal of this petition with a liberty, full stop. Yes, Deputy J. L. L. Devi, so is present. Petition is accordingly dismissed. However, with liberty. Dismissed on withdrawal, however, with liberty. Ten.
Pilot matter may be taken up to 100, Lordship.
What is-
Otherwise, notice may be issued because
What is the matter?
dismissal from
Dismissal. As what?
you're the AP concept. Arm branch.
After a DP?
Yes, then appellate authority.
Okay. What is your name?
Yes, Lordship.
Part 3 Islam Learned Counsel for the petitioner, who by means of this petition has put to challenge an order of dismissal from service dated 30/9/2023. Full stop. The petitioner was working as a constable AB. Full stop. The departmental appeal has also been rejected. Full stop para. Let rule be issued. Returnable by 6 weeks. For all, Mr. Bora, D. Bora for all, extra copies within 3 working days. Sri Bora shall also procure the relevant records of the disciplinary proceeding.
Okay.
11. এইটো আৰু নামি গৈছে কেমেৰাটো উঠাই দিবলৈ আৰু বাস
Dismissal from service.
same as
LDA in the foreign.
LDA, which department?
LDA in the
Foreign
foreign
tribunal.
Foreigners Tribunal. After a DP?
Yes.
APAL, Dismissal order as LD in Foreigners Tribunal, Morigaon. Foreigners Tribunal 2nd, Morigaon. Dismissal order है 1/6/2022 and appellate order लिखा है क्या पहले में? नहीं लिखा ना? Appeal has also been dismissed. Okay. For all respondents?
No, my lord. I will take notice for 1, 2, 4, and 5. The member Foreigners Tribunal, my lord. This SC Foreigners
Home.
Tribunal. they will
SC
take-
home, I think.
My lord,
Mr. Paying is
SC
there.
home, I think.
my
Yes.
lord, I would like to alleviate some confusion in this regard. With regard to the task of the FT council, only to deal with the issues which are related to foreigner issues, not this service matter and administrative matters. In administrative matters, on earlier occasion, if your lordship would see,
No, you have made a party. We
only
are not
government
able to-
advocate can deal with
No, my lord, we don't.
on behalf of the member.
Mr. Paul, it is not on the what the functions have been discharged, whether he's been authorized to take a notice.
But there is no,
How do you distinguish that for this matter, government advocate will?
I cannot distinguish it, but so far as our last occasion.
So it's
possibly-
already there for the other respondents that you serve a copy on Mr. Payang. Is it there in the court?
Yes, yes.
Uh,
There are
three-
3, 4 standing
Okay.
counsels, my lord. They
Please
will take-
inform one of the names, okay? Sri,
Mr.
if
Payang.
J. Payang, huh?
J. Payang.
You're for 1, 2, and 3. 1, 2,
1 to 3, 1 to 4 and 5.
1, 2, 4, and 5. Ardhar, State Council. J. Payang, R3. Extra copies, 3 days. Okay. Take steps. Serve copies. Mr. Deca, what is this?
Lordship, this is regarding the HPO recruitment, Lordship, in 145 post of AISF constable. Lordship, although the advertisement is of 2017, the results came in 2022. Thereafter, some unsuccessful candidates, they approached this honorable.
What is your grievance?
Lordship, our grievance is that although we have served for 5 years in the district of Kokradar as SPOs, Lord, but we were allotted only 2 marks instead of 10, Lord.
Yes, we issue a short notice.
Otherwise, your lordship,
We had dealt with few of the matters, I think.
Lordship,
your lordship, this,
Yes,
We had given average marks.
I think page number 39, your lordship order is
your
only there,
lordship
your-
order is there, Lord.
30?
Page number
Yes,
39, it
39.
starts.
Yes. What did we say?
That 2 marks be given to all the petitioners in that.
That
petition.
average
Yes, Lordship. And seven petitioners have been already been appointed, Lordship, thereafter.
of this case.
Yes,
of,
Lordship.
Of that
Of
case.
that case. 10/5/2024.
74, 75, your lordship.
Page number 73, the order, sir.
70?
Please,
Okay. Is it covered?
covered, Lordship.
Your lordship, since I got it the first occasion.
Okay, we'll have it for disposal on Wednesday next or Friday next. You take the minimum instruction.
Lordship. Lordship, thereafter, another 2 writ petitions have been filed. In those writ petitions, notices have been issued and a direction have been given to the government to re-verify the documents of those petitioners. In those 2 writ petitions, the latest order is of, your lordship will find at page
15, sir.
84.
84.
Yes, lordship. 15/7/2024, order dated. Although it starts from 83, the relevant page is 84, and from 85 is the order.
Is the verification exercise still going on?
Then if it is still continuing, then the same they
No,
can.
is it going on? There, you had made a categorical submission that the verification process was being carried out.
Okay.
At page 85, towards the last
Yes,
part.
yes.
I have an instruction that these petitioners have been already been called for re-verification.
No, is it going on?
Yes, Lord.
That way, the same interim measure as if it is. If the verification process is going on, your lordship,
Yes.
even like that.
Okay, we'll pass the same order at page 84. Notice of motion and okay, let's pass the order. R3 D Deca Learned Counsel for the petitioner. One petitioner.
Lordship, there are 3 petitioners. Lord.
Petitioners
Yes.
whose grievance is that appropriate marks have not been given to them in the recruitment process for filling up 145 numbers of post of constable within bracket GD in the Assam Industrial Security Force within bracket AISF. Full stop. It is submitted that the petitioners were earlier appointed as special police officers within bracket SPO under section 23 of the Assam Police Act 2007. And there is a judgment of this court dated 10/5/2024 in WPC 3734 of 2022 for giving certain benefits to such candidates. Full stop. The learned counsel for the petitioner has also submitted that the verification exercise is going on. Sarah, let notice be issued returnable on.
Lordship, the other case is returnable on 19/8/2024.
Returnable on 19/8/2024. Sri C.S. Hazarika, London State Council, access for all the respondents, extra copies within 3 working days. Sri Decca prays for an interim order. It is after hearing, it is provided that if the verification exercise is going on, the petitioners shall be given an opportunity for their credentials to be verified.
May it please the Lord. Lord, this man is initially worked as a Jawan in the Assam regiment. After that retirement from the Assam regiment, he joined the Sainik Welfare Board as a grade 4 employee, my Lord Chowkidar. He was appointed for the first time in Lakhimpur in 2008, and he worked there for up to 11 July 2014. Then he was transferred to Tezpur, and he worked there from 2014 to March 2018. Then he was again transferred to Mangalore, and since 2018, till the cause of action arises, he was there. He was supposed to retire in June 2025. And he was transferred again to the Hailakandi. And he had some personal difficulties, medical conditions, and marriage of his only daughter. So he represented his case to reconsider because
You want withdrawal of your resignation?
my Lord, prayers are alternative. If it can be treated as a VRS, that also I'm happy. Because if it is treated as resignation, I may not be getting the retirement benefit. And towards the end of my
Heard Sri H. Amo, Learned Counsel, for the petitioner. Full stop. The petitioner claims to have served the Assam regiments of the Indian Army for over 18 years and was thereafter employed with the Sainik Welfare Board in grade 4 capacity. Full stop. Due to certain personal reasons, the petitioner in a haste had submitted
tendered a conditional resignation.
Had submitted a resignation as prior to that an order of transfer was passed, which the petitioner, due to his personal problems, was not able to comply with. Full stop. The present petition has been filed to convert the conditional resignation into a voluntary resignation, voluntary retirement, or for withdrawal of the same. Full stop. Para. Let notice be issued, returnable on by 6 weeks. Here for all. C.S. Hazarika for all. Extra copies within 3 working days.
I'm obliged.
You look into it if something can be done. Have you filed any representation?
Many.
May I please speak? This case related petitioner engaged as volunteer in the water supply scheme. He was engaged in 1916, and by new resolution taken adopted lawsuit to appoint the landowner's son as per their birth son, but scheme said that existing volunteers to be continued.
You're a volunteer.
Volunteer.
You claim to be continue.
And some money has not been paid also. 1 year also paid.
Yes, Mr. Bodhau.
Lordship, here volunteers are actually not engaged by PHC department. They are only trained to operate the pumps. Otherwise, they are engaged by the water user committee, which is members of the locality are using that.
Water user committee is the party here.
President.
Have you made them party?
Department is a party, Lordship.
Water user committee.
Water user committee
That is under the
President.
Panchayat.
It is the party, Lordship, and
Party.
respondent six, Lordship.
The party.
But do you have any right?
Lordship, since
Lord.
government has sanctioned
That
money,
is why it is called volunteer, Lordship.
volunteer,
because
yes,
they are-
but yes, Lordship, kindly look into the paragraph, page 31, page 23 notification.
Can
Lordship.
you force yourself to be
Page
a
20.
volunteer if they do not want?
Lordship, page 25 may kindly be looked in the notification.
Okay.
Lordship. Page 25.
Third, Sri F.U. Borvia Learned Counsel for the petitioner who claims to be engaged as volunteer in the Hatimara Dokhin Kenduguri Pani Jugan scheme in the year 2016. Full stop. It is also submitted that from time to time, comma, the government had released certain amounts.
Lordship.
Full stop. However, the grievance of the petitioner is that a resolution has been taken whereby there is no provision for engagement of volunteers. Full stop. Para. Your
Notification says that
your-
at least in
your pending salary is also there.
pending salary is
The petitioner has also raised the issue of non-payment of arrear salaries. Full stop. Para. Let notice be issued, returnable by 6 weeks. Yes,
Lordship.
for
One submit notification.
PhD department.
we know PHE for
Respondent 3, 4,
no one also
1,
One is-
3, 4, 5.
1, 3, 4, 5. I Bothakur, madam. P Biswas S Datta PNRD for 2
Two.
extra copies within 3 working days. Steps forest responder 6 registered
Six.
post with AD 3 working days.
Oblige. Small prayer, Lordship. Typographical error is there in the annexure type, Lordship. I may allow to correct it.
Annexure means number of the annexure.
Yes, only one annexure.
Page, what is the
Page Lordship. That is page 17, Lordship.
17?
17.
What is the nature of correction?
Page 17, Lordship, start one.
Yes.
If line with villagers of Fatimara here is in respect of coming, that may be
Page 17,
page 17 and 18 first line. Lordship. First
page
part.
18.
Page 18 first at the end. The
At the
meeting
end,
was
it was-
ended.
Yes.
At the
at-
end to be deleted.
At the end,
And
the meeting was
meeting was
ended.
ended by the.
Doesn't matter.
Lordship. Oblige.
Oblige.
May I please order?
Assam Secretariat Service Assistant.
The members of the Petitioner Association, my lord, working as the senior administrative assistant. Now it is designated as assistant senior.
Mr.
assistant
Chalia, we're
Lordship,
given your name in one first.
The withdrawal papers.
Yes.
Lordship, they are aggrieved by the, with the,
Area D and DR.
my lord, the fixation of pay, great pay. And they have approached the pay anomaly committee, my lord. And anomaly committee recommended their proposal and forward the matter to the administrative department along with the finance department. Matter was placed. Thereafter, finally, the finance department reverted back the proposal, and finally the page number, my lord, 57
Yes.
from Sancho Sir, with reference to above, I am directed to inform you
67,
57.
57. Yes.
Lordship. This is the communication to the association, my lord.
Yes.
The relevant para, sir, with reference to above, I am directed to inform you that you that there is no action to be taken, and as such, ASA is advised to place their demand before the next pay commission as and when constituted. Thereafter, the petition is before your lordship. Lordship, in this case, my lord, notice may go.
Heard Ms. P. Bora, learned counsel for the petitioners. Full stop. It is the case of the petitioners that the members of the petition number 1 association are working as senior administrative assistant, which has been now redesignated
Sure.
as assistant section officer in the Assam Secretariat. Full stop. The government had taken a decision for providing additional service benefits to certain employees, and on that issue, the petitioner association had raised the matter before the appropriate authorities, which was sent to the Anomalies Commission. Full stop. However, the matter has not been favorably considered and rather directed to be deferred and rather deferred for the next pay commission as and when constituted. Full stop. Para. Let notice be issued, returnable by 6 weeks. Shall you have for GAD?
To GAD, Lordship.
GAD A. Fukan, is he there?
Yes, Lordship.
A. Fukan, please ask him to come to the court. A. Fukan, Standing Counsel GAD
The
1.
name has not been shown. Lordship.
Okay, well, and 2 and 3, A. Chaliha. Extra copies within 3 working days. The name of SCGAD be reflected in the cause list.
Oblate.
You serve copies on Mr. Fukan also.
Lordship.
Mr. Chaliha, please inform Mr. Fukan.
Item 16. Wait, Vijay. Lord, the short point involved in this case is whether on the same set of charges, criminal as well as disciplinary proceedings can go on. And if your lordship will kindly come to page number 26, my lord.
But the last Stangen case, I think 1 year is the case of Stangen, I think. What is the case? Stangen.
Stangen, 2014 PSDC.
I think 1 year has been given.
Yes.
That is the
No,
period.
if we go by the case laws on the point, starting from Kusheshwar Dubey to my lord DM Tang, everywhere it has been said, when it is only exception, otherwise there is no bar. Because the standard of proof is different.
No, in this Stangen, I think, have you read Stangen? Everything has been from Captain Paul Anthony, everything. GM Tank has not been. The tank is on a different. If it's the charges are exactly same and you are honorably acquitted, that is the expression.
No, GM Tang was a case where in the disciplinary proceeding, he was, vetted out with punishment.
Understood, but in the criminal case,
Here also same set of facts. That's what I was trying to
no,
show.
you are trying to stay prayer for stay of the department proceeding.
Yeah, yes.
That has not culminated.
No, the question is now, if I am to proceed in the disciplinary proceeding.
No, that is why.
Yes.
That is why we are not saying that we are declining to pass any interim
Yes.
order.
Yes.
The maximum time has been given as 1 year in
1 year.
Stangen.
Ah.
After taking into, because it cannot go indefinite.
Indefinitely.
And at the same time, they cannot also linger with the criminal case.
Yes.
So that you do not suffer a prejudice in the criminal case.
Question of striking a balance.
Balancing.
Ah.
What is the, Mr. Bora, Stangen, you have the citation?
Yes, it is 1 minute.
Mr. Patwari, just have a look.
2014.
36.
636.
60.
Hard 3K and so on.
Lordship is going to pass the interim order, my lord. No. I may be, my lord, allowed to obtain instruction.
Now you have to instructions. We are not,
Regarding-
it's only for till the returnable date.
Yes, still did.
No, my lord, if it is stay, my lord, I will have to, I have experienced one, my lord. After passing the, my lord, stay order, I obtained instruction that they inform us that already inquiry has been completed in Department of Proceeding. Now we are sending it for Department Authority. That's why I'm asking, madam.
That case.
No, no, that's not a, if stay order is already there tomorrow they will
My
say
lord,
that we
only
have already
inquiry,
completed.
only inquiry officer has been appointed at this stage.
No, madam, I don't know, madam. That's why I'm
No, that is the
asking.
statement.
And by this, madam, the case also.
No, Mr. Chutia, you, in a given case, it might happen
Yes.
that we stay, but in the meantime, inquiry is over. In that case, stay will be meaningless. It
That-
will be meaningless. It is only at the stage of facing the inquiry that the prejudice question will come, not thereafter.
So far, madam, our case of 2022, 3 CLC also 171 division bench, discharge EM2. Completion of departmental proceeding court declined to interfere with the departmental proceeding, directed to complete the same in June. So we is departmental proceeding.
You do one thing. We'll have it on Wednesday
No, no,
next.
it is stated in
No, we'll have it on Wednesday next.
Wednesday, madam.
You have the instructions. What is the stage of the inquiry?
Yes.
Otherwise, we're inclined to pass an interim order
Then my lord, status quo as on today be maintained.
till Wednesday.
Huh.
Okay, Heart Sri K. N. Chaudhary, Learned Senior Counsel for the petition assisted by Sri J. Patwari. Full stop. The issue which has been raised is whether a departmental proceeding can be conducted at the same time when a criminal case is going on the same set of charges. Full stop. Para. The issue has been substantially settled by the Honorable Supreme Court in a catena of decisions which have been taken into consideration in the case of Stangen versus so-and-so, 2014?
3 SCC 636.
36, full stop, para. Sri T.C. Chutia, the learned additional senior government advocate Assam, has however submitted that he may be allowed some time to obtain the instructions of the stage of the inquiry. Full stop, para. Let such instructions be taken and the matter be listed for motion on Wednesday. Wednesday, nothing is going to
Yes,
happen.
Wednesday, 31st.
31st.
Item
The
19 same.
Voter day.
19?
19 is same, Mila. He is accused number 75.
Okay, same case.
Same case.
Okay.
Only Thursday, date of birth, everything is same, past.
Same day.
Same.
Complete.
Please, Mr. Patwari, give an extra copy.
Yes, right now, right now.
Sri Patwari, the learned counsel assisting the senior counsel for the petitioner shall furnish extra copies of the writ petition to enable taking today itself to enable obtaining of instructions.
Deeply. Well, okay.
Item 17.
May I please, your lordship. My lord, the petitioner before your lordship is a dental surgeon, lordship, who was lordship appointed in the year 1992 under TF of regulation TF of the APSC lordship.
Yes.
Subsequently, his service was regularized on the recommendation of the APSC lordship in the year 2001. But lordship, during this period, lordship, for some certain months, lordship, he was not receiving any salary, lordship, and accordingly, he preferred a writ petition before this honorable court, lordship, which was disposed of by this honorable court by order dated 25/3/2013, lordship, and writ petition was filed in the year 2004, lordship. So ultimately, after passing of this order, lordship, when the authorities not considered the prior, lordship, then he preferred a contempt petition, lordship, and after filing of contempt petition, lordship, certain interdepartmental communications were made, lordship, for releasing the salary, lordship. But suddenly, lordship, without awareness of without knowledge of the petitioner, lordship, in the year 2018, lordship, the matter that contempt petition was dismissed for default, lordship, for non-prosecution, and the entire matter was stopped, lordship, for releasing the salary, lordship. And petitioner, lordship, recently came to know that that petition was dismissed for default, lordship. So, lordship, petitioner praying before your lordship for releasing the salary of his unpaid salary, lordship, for June 1995 to December 2000, April
to December 2001, Lord.
Now, how do you renew this issue? It has been decided. Why don't you take steps for reviewing, for restoration of the contempt case? It has not been dismissed on merits.
Because Lordship, recently petitioner had got
Now,
the
how do you
knowledge.
again raise the issue? Issue has been settled by this court. You cannot raise the same issue
Yes, Lordship. But
in the same forum.
because Lordship, subsequently some interdepartmental communications were made
Does not make a difference.
between the department, Lord.
Not make a difference. Where are the interdepartmental communication?
Lordship, I have
Page.
attached all those, Lordship.
Page,
Page 41, Lordship.
date,
Page 41, Lordship.
date,
Date 6th May 2015.
2015. When was the contempt closed?
During
2018.
pendency of the contempt, Lordship.
So-
All the communication.
At best, you can restore the contempt matter.
Lordship, then Lordship, I may be allowed to withdraw, Lordship, with a liberty to.
What liberty will not grant liberty? It's your, where should we advise you? How do you raise the same issue in the same forum?
Well, ultimately, Lordship, the petitioner's grievance was not
So,
resolved, Lord.
for whose fault? Can you again come? After a few days, again you will come. One issue which has been adjudicated, we cannot reopen the issue again. Heard. 3. N.H. Borbia, learned counsel for the petitioner, who has raised certain issues regarding the pending salaries of the petitioner for services rendered by him as dental surgeon, which he was appointed under Regulation 3F of the APSC, within bracket limitation of function, Regulation 1951. The period, however, is of the year 1995 to 2000 and 95 to 2001, 2002. Full stop. The petitioner had earlier approached this court on the said issue by filing WPC 7935 of 2004, in which there was an order dated 25/3/2013. Full stop. The petitioner had thereafter filed contempt case number 184 of 2015, which was, however, dismissed for non-prosecution on 21/3/2018. Full stop. The learned counsel has submitted that there have been certain inter-office communication for which he has filed this case. Para. Also heard Ms. S. Sharma, learned standing counsel, Health and Family Welfare Department, appearing for the respondents, who has raised the issue of maintainability. Full stop. Para. Apart from the fact that the cause of action for salaries is till the period of 2002 and the of 2002, and this writ petition and the cause of action is sought to be raised after more than 2 decades, comma, this court has found that the issue was already adjudicated in the earlier round of litigation instituted wide WPC 7935 of 2004, which was disposed of on 25/3/2013. Full stop. As indicated above, comma, the contempt case being contempt case number 184 of 2015 was also dismissed for non-prosecution by this court wide order dated 21/3/2018. Full stop. The petition demonstrates lack of due diligence. Full stop. Petition is accordingly dismissed.
My lord, may I allow to withdraw it? Otherwise, lordship, if subsequent lordship any.
Due diligence, full stop. At this stage, the learned counsel begs to withdraw the writ petition, full stop. Writ petition is dismissed on withdrawal.
Good.
Make please, Lord. My lord, this petitioner was the superintendent engineer in Dhaka University. He retired in 2016. He released leave encashment benefit and gratuity was not released till today. He was retired on 23/6/2016, my lord. And at page 17, the letter submitted by the petitioner is there, my lord, where it indicates he total 13 files with photocopies of the vouchers were submitted by the petitioner. And the list of name of the work my
But
lord.
why did you spend on your own?
My lord.
Why did you spend your own money?
No, my lord, they give advance. They give advance. Out of this advance, we spend the money now. As because these documents, they have lost. They have deducted my LEB and gratuity. They have given advance from time to time. Against that, my lord, I have to submit.
Okay, heard Sri R. Goswami learned counsel for the petitioner, full stop. The petitioner was working as a superintending engineer.
Yes.
In the Guwahati University, and he had retired from service on 2016.
23/06/2016.
23/06/2016, full stop. However, his leave encashment and gratuity has been withheld on the ground that withheld, full stop. It is alleged, has been withheld, full stop. And it is alleged that such withholding is because of the fault of the university in misplacing certain documents and not attributed to any fault of the petitioner.
Yes.
Sarah, that notice be issued, returnable by 4 weeks. Your name?
Okay, on behalf of
AD. Sri A.D. Learned Counsel appearing on instruction of Sri P.J. Fukan.
PJ.
Standing Counsel, Guwahati University accepts notice on behalf of all the respondents. Extra copies, free working days.
Yes. Yes. Supply. I did.
18.
Here the respondents Staff Selection Commission issued an advertisement on 17/7/2021
Yes.
for the post of Constable DT in Central Armed Police Force. The petitioners participated, but they are unsuccessful. But they have filed this writ petition on the strength of clause 3.2 of the advertisement, Lordship. That is at page 19, Lord.
Yes.
Lordship, may I read, Lord? 10% vacancies are earmarked for ex-servicemen ESM. If suitable ESM candidates are not available, vacancies reserved for ESM will be filled by non-ESM candidates.
Those vacancies have not been filled up.
No, Lordship. The vacancies, your Lordship will find at page 77, Lordship.
No, your case is those vacancies have not been filled up.
No, Lord.
You have a claim on those.
Yes, Lord.
In that quota.
Yes.
You belong to ex-servicemen.
No, we do not belong to ex-servicemen, but if ex-servicemen posts are not filled up, then they will be filled up from the other categories.
Yes.
That's
So
what
how is your claim that you will be getting those posts? There may be others.
But they have not filled up those posts, Lord.
How many of you are there?
We are, Lordship, 4 petitioners, Lord.
Madam?
Notice that
But can you claim that those
Lordship,
posts?
There is a similar petition which was filed before this honorable court, Lordship, that your Lordship will find at page 78, Lordship.
7-8.
78.
Yes. What has been stated?
Lordship, same case, Lordship, wherein 8 number of posts were kept vacant for those petitioners in that petition.
But what is the total number of vacancy under this quota?
153, Lordship, only 2 posts were filled up, Lordship, 151. And thereafter,
153 is meant for ex-servicemen.
ex-servicemen, Lord.
Third, we need a learned counsel for the petitioners, full stop. The petitioners are aspirants in a recruitment process initiated by the advertisement dated 17/7/2021 for the post of constables within bracket GD in the Central Armed Police Force, comma, SSF, comma, Rifleman GD in the Assam Rifles and Sepoy in NCB. Full stop. It is the case of the petitioners that there is a quota for ex-servicemen within bracket ESM, which according to the petitioner consists of 153 numbers of posts. Full stop. The petitioners rely upon clause 3.2 of the advertisement, which stipulates that in absence of suitable candidates under the said quota, comma, the post would be made open for general category candidates. Full stop. The learned counsel has also referred to a similar to an order passed in a similar petition directing the respondents to keep certain posts vacant. Full stop. Para. Let notice be issued, returnable by 6 weeks. Ms. S. Borua, learned CGC accepts for all, madam?
Yes, sir.
For all the respondents, that extra copies, no, within 3 working days. Para. Uh, 3 Deca. The learned counsel prays for an interim order. Para. It is provided that till the returnable, it is provided till the returnable that if the post POSTS, which were reserved for ex-servicemen are sought to be filled up by general category candidate in terms of clause 3.2 of the advertisement, comma, 4 numbers of post be kept vacant. Full stop. The aforesaid interim order would, however, be reconsidered on receipt of the instructions.
Lordship, Lordship, 20 similar, Lordship, only the advertisement is of 2022 and the number of vacancies are more than 2000.
What is the number?
Number of vacancies is 349, only 1 post was filled up.
349 ex-servicemen. Ex-servicemen.
Ex-servicemen, Lord.
Okay. How many petitioners?
Petitioners 4, Lord.
4. Advertisement date to date. আমি আগৰটো advertisement date লিখিছো নেকি আগৰটো? লেখা নাই নেকি? It advertisement date to. What is the date of the advertisement?
27/10/2022.
And clause is the same.
Same clause 3.2.
আৰু number আছিল 153 আছিল আগতে, এইটোত কিমান আছে? 300?
Total is 349, 1 post filled up, 348 remaining.
349. And 1 post has been filled up and 348 remains. ঠিক আছে? Madam, you for all the responses.
Yes.
Yes. Okay. Yes.
Petitioner is a disabled person.
You are a
Disabled person.
disabled. Okay.
Disabled. They selected in a selection process for appointment, and they hold a certificate for benchmark disability. And after the selection, my lord, the authority has conducted a reassessment for benchmark disability, my lord, and found him less than the benchmark disability. And my lord, under the act, my lord, these disabled persons are granted with the right to non-discrimination on the ground of disability. Whether
Non-discrimination on
Now,
the
if you do
ground.
not fulfill the benchmark, then how do you? There may be many in your category.
Yes, my lord. Whether,
There
my
has to
lord,
be a
the-
selection.
The 4% reservation, my lord, as per the act, my lord. The 4% reservation, my lord, reservation that act means the reservation for PW. Not less than 4% shall be, every appropriate government shall appoint not less than 4%, out of which, my lord, out of which 4% post shall be identified for benchmark disability category wise, my lord. And the reservation for person with disability, my lord, shall be horizontal, my lord. Now, the post which has been identified for benchmark disability, my lord. Section 34, subsection 2 says, if my lord suitable person is not available, my lord, then PWD person can be appointed on that post. My lord, the person with disabled person, my lord, to get the appointment on the post of identified post, my lord, the concept of benchmark disability cannot be constricted, cannot be a
But the posts have to be identified. An exercise is done. What post can be done by which person?
My lord.
The posts are identified that
Yes.
this particular post is open for this kind of persons with this kind of disabilities.
And is the act, my lord.
First, we issue notice, Mr.
My lord, a fresh advertisement has been issued, my lord. One post may be given.
You participate in the sale for press advertisement.
Already, government, my lord, actually, can you see the,
Now, why should we keep a post vacant?
Yes.
Because-
Lordship, similar matters were dismissed, Lordship, and he has
No,
preferred an
I-
appeal before the
at the-
division
at-
bench. And the division bench was about to dismiss those writ appeal, but then the petitioner sought for
No,
liberty,
no.
and the writ appeal was withdrawn with a liberty to file a revision.
No.
Review, Lordship.
At the lane, my lord, honorable AG was present, my lord. After satisfying that, honorable division bench says that you go to the fingerprint and ask review on the law appointment.
Have you filed a review?
No, Lord.
Yes, I will file that now. That's today was listed, my lord.
It was
And
listed
another
on 24th, Lordship, writ appeal number
Okay, my lord.
228 of 2024.
kindly for clarification, my lord.
If there's already a judgment which is which is holding the field, can we take another review?
Lordship,
But
writ
that,
petition
that,
number
my lord,
2091 of
that
2000.
judgment, my lord, has not considered my right under the 2016 Act, my lord.
So that is why a review has been directed to be filed. You
Yes,
get an order
yes.
in that. Once it is adjudicated, can you go for a fresh adjudication? In accordance with law, you file a review, it will be considered. Heard Sri S. Roy. S.K. Roy, learned counsel for the petitioner. Footstep. Para. Sri D. Upamanyu, learned standing counsel. Health and Family Welfare Department, however, submits that the same issue was unsuccessfully raised by some petitioners in a writ petition, and in the appeal preferred, the appeal has also been withdrawn with liberty to prefer a review. Review has been filed or not?
No, Lordship, it was withdrawn on 24/7/2024.
Appeal was withdrawn recently on 24/7,
And the
2024.
appeal number is 228 of 2024.
Writ appeal number 228 of
2024.
24.
Yes.
Petitioner was preferred an appeal being WA number 224 of 2024, which was withdrawn on 24/7/2024. However, with a liberty to file a review. Footstop. Till now, such review has not been filed. Footstop. Para. In view of the above, the consideration of this matter is not deemed, will not be proper at this stage unless some orders are passed in the review that may be filed in those cases. Full stop. You are the same counsel.
Yes.
Sri Upamani has also informed this court that the counsel in the other case is the same. Full stop. Para. List this case for consideration after a month, after a month for motion, by which time the learned counsel for the petitioner may apprise, on which date the learned counsel for the petitioner would apprise the outcome in the review petition.
Highly object.
Is the other earlier judgment here annexed?
No lordship. Dismissal lordship order, no lordship.
Mentioned? Not mentioned?
My lord, that,
You have not even mentioned.
No,
no,
lord.
no, I have,
No.
no,
Earlier case, you have not even mentioned. Mr. Roy, what is this? Isn't it your duty to point it out?
Yes.
This is not proper practice. Even if you are not the counsel, you should know that this matter has been adjudicated. At least make a statement.
I should. Sorry.
This is a equity court. You should be fair to the court.
Yes.
Where is your bona fide?
I forgot that aspect.
It's not a question of forgetting. It's a question of misleading this court by suppressing material facts. You forget the issue that has been raised on 24/7. Writ appeal has been dismissed on 24/7. Today is what date?
My lord, today is also listed another.
Why haven't you mentioned?
Yes.
Don't spoil your impression, Mr. Counsel, like this.
Sorry.
We'll remember these things.
Public.
22. Yes, Mr.
Yes.
Kulita.
Matter pertaining to risk and hardship allowance to the petitioner, my lord. There is second round of,
Risk and hardships.
yes, my lord. Second round of litigation, my lord. In earlier litigation, my lord, honorable court has passed order, my lord, in page 79.
Thereafter,
My lord, respondent submitted, my lord, that this is under consideration. One review committee was established, my lord. But my lord, till today, review committee has not given any decision. That, my lord, that is my grievance. For that, my lord, allowances, my lord, till today, my lord, stop, my lord.
no, was it given earlier?
Yes, my lord.
But
earlier
that was the subject matter of the earlier writ petition. You could have come for contempt.
No, my lord, the contempt.
Where is the scope of fresh adjudication?
Kindly see, my lord, page 78.
78.
Yeah.
Okay.
Contempt, my lord, I could not file contempt because, my lord, there is no specific direction. Page 78, kindly.
Yes.
Please, WPC number so and so filed by so and so Benny D and High Court of Guwahati regarding recovery of risk and hardship allowance. Please FRU signal dated so and so NES dated 2/6/2020. The case was taken up with MHA and MHA filed it in dated 28/6/2023 has intimated that the case is under consideration with committee for review of classification of field areas, which has been constituted by MHA OM dated 6/12/2022 and
Okay.
report
Heard
from
three
the
M. Kulita, learned counsel for the petitioners. Full stop. The issue is on the aspect of risk and hardships allowance. Full stop. The petitioners had earlier approached this court by filing WPC, by filing writ petitions, which were disposed of via a common judgment and order, via a common order dated 24/8/2023.
Yes.
Full stop. This court has taken into consideration a communication as per which the matter was under active consideration in the MHA. Full stop. It is submitted that till now no decision has been taken or conveyed. Full stop. Para. Let notice be issued. Returnable by 6 weeks. Madam, for all.
Yes, sir.
B. Sharma, London CGC for all respondents. Extra copies, 3 days, 3 working days.
Obliged.
Yeah, please, sir. Hello, in this lawsuit, 2 issues involved. Hello, first one is the petitioner lawsuit was placed under suspension on 8/8/2023, but the order has not been reviewed till date.
8/8/2023.
8/8/2023.
8/8. DP
2023.
initiated.
My lord, DP initiated, but my lord, second issue is, lordship, after submitting the inquiry report, lordship,
8/8/23 suspension.
2023.
As what?
My lord, I was arrested on 7/8.
As. What are you working as?
My lord, Latmundar.
Latmandal.
My lord.
Arrested when?
Arrested on 7/8/2023, and this suspension with given effect from 7/8/2023.
Okay. Then
My lord, thereafter, lordship, petitioner was released from on bail. Subsequently, lordship, I filed an application on 7/10/2023. But that application has not been considered. Inquiry proceeding was started.
when?
My lord, inquiry process was started, and lordship, inquiry report submitted on 15/3/2024.
Inquiry report also given.
My lord, after that, lordship, the disciplinary authority, lordship, did not agree with the inquiry report, and they have, lordship, decided to de novo inquiry.
Let us see.
Lordship, de novo inquiry, that order, lordship, we have challenged, because that is bar under law, lordship. The,
Where is the de novo? Let us see the language.
my lord, that is 36/2020, page 48.
48.
My lord. My lord, in the meantime, lordship, we filed another petition that has been,
48.
my lord. My lord, rule 2000 of appeal and disciplinary rule, lordship. Rule 9, clause 9, provides, lordship, they have ample, lordship, power to re-examination the inquiry report, evidence, etc., and reconsider that. But they are, lordship, they cannot, lordship, start a de novo inquiry, lordship. There is this.
Now you said that the inquiry officer was in your favor.
My lord, it was not absolutely in my favor. I have an exact, lordship, inquiry report. My lord, page in my additional affidavit, lordship, page 59.
No, that cannot be Mr. Hendik. Who's there, Mr. Chutia?
Lordship, may I kindly see the first.
No, you come
Lordship.
to page 48.
No, I will come a little later on. Lordship, may I kindly go to the annexure 9, page 38.
38.
38, in a DPT.
Yes.
This is the notification issued by the, my lord, Principal Secretary, Revenue Department.
311.
311.
Yes.
Lordship, Assam Land Assam Land Record Subordinated Service Rule 2023, Lordship.
Hmm.
It is, my lord, my lord, and my lord, it is effective from 1 April 2023. Earlier, my lord, there is no service rule regarding, my lord, that Mondal and other, my lord, that. Subordinate, my lord, caters for. So 1/4/2023, the appointing authority is the Director of Land Record.
Disciplinary authority.
Disciplinary, yes.
Not appointing authority, disciplinary authority.
No, lot of, also, my lord, appointing authority.
Appointing and disciplinary, same.
Lordship.
Oh, yes.
And Lordship, my lord, this order was passed on, my lord, 3/11/2023.
Yes.
My lord, that whole, my lord, that appointing authority, Lordship, there is given specific. The land record assistant, my lord, earlier, my lord, it is state, my lord, lot Mondal. Now, my lord, is a designated. It is the land record assistant.
Okay.
For that, Lordship, when it was, my lord, then notified, then, Lordship, the this order was passed in page 48 and etc. 12.
Page
48 Annexure 12.
That is the impugned order.
Yes.
Lordship. In the meantime, my lord, that inquiry has been completed.
Yes.
There's some inquiry has been going on. My lord, after my lord, that when the notification was issued, it should be stopped. My lord, cannot be, my lord, continue the inquiry of my lord, that inquiry. As because my lord, they already been appointed, my lord, some other power is given to the some other person. As per the my lord, that notification of 38, my lord, page 38.
No, but is this 48 citing 38 as the ground of discarding the inquiry officer report?
Well, why it has been given, Lord, kindly goes to the my lord, that inquiry report, Lord.
No, we are not on the inquiry report.
But it is not a denial, it is going to be the press notification, my lord, that kindly goes to the that 1, 2, 4, 5, 6 number of paragraph.
Yes. Whereas
the oral evidence of independent witnesses, flying officers, and the investigating officer of the Director of Vigilance and Anti-Corruption in connection with the PS customer not seem to be taken during the course of inquiry. If it is not done, Mala, how can Mala it is proved that he is Mala doing this?
inquiry officer was appointed by you. If the inquiry officer fails to do his duties, you take action against him.
Earlier, Mala, the inquiry officer was.
No, Mr. Hendrik, this will give a very wrong signal. In one case, yes, you may find, but this, anybody can misuse it. The expressions used by this court is unless you get a inquiry report in your favor, you will keep on going the inquiry. That is not the purpose of.
No, my lord.
Those are the expressions used in many cases, from Bidyut Boragohai to all those cases. Mudoi, B.R. Mudoi.
My lord, that as part of
No, but Mr. Hendrik, you may have a good ground, but those grounds have to be reflected in the impugned order. It's not reflected. See, what is the reflection in the impugned order? That the inquiry officer had made recommendation of penalty to be imposed, which is outside the purview. You ignore the suspect. Inquiry officer says that impose some penalty. You ignore the suspect. He's not bound by every.
Absolutely.
And if he has reasons to disagree with anything of the inquiry officer, the petitioner, a delinquent, can be given notice. That is the law.
It is totally been noticed.
No, but you cannot go for a new inquiry, de novo inquiry.
Well, it is not only the de novo, it is a fresh inquiry.
Fresh inquiry is de novo inquiry. What is the meaning? And if there was an indication that there has been change after coming into the rules of 2023 as notified by the notification of 3/11/2023, that there is a change of disciplinary authority. That is not even a ground. And in any case, this change of disciplinary authority will not make change in the inquiry. Inquiry is made by an independent person. He is an inquiry officer. He puts it before the disciplinary authority. There is a change. Now the new disciplinary authority will look into the matter.
But today is the date, my lord, he was asked to appear, my lord, before the my lord, that inquiry.
I have also, they have also.
Where are the case laws?
My lord, yes.
Which one? Bidyut Boragohai.
My lord, I have.
B.R. Mudoi. Then what was it? Then Bora. What was the Bora?
Even then, my lord, as per the my lord, Assam
Bora.
appeal rule, lord.
What was the name?
The rule 13, my lord, there is a provision for appeal.
You have got Bidyut.
Bidyut I have given lost. One is anomalies in Thala. So that is judgment.
Have you got 71, that first judgment of Supreme Court? Did you get the first judgment of Supreme Court? 71. Yes, and that B.R. Mudoi is there. B.R. Mudoi is there. Then that Bora case is there.
Yes, two cases there.
Bopoti B.R. Mudoi. These have been settled and all based on 71 case. That day, I think. What was the name? Forgot the name.
But these are not pertaining to the same. And so far, lordship, mandatory requirement of review, that is lordship in the division bench judgment, lordship.
It is also, my lord, that in last, about one matter on day before yesterday, lord, the one order was passed by Honorable Justice, my lord, S. Yeah.
We'll issue notice and we hope, we,
My lord, this is the order.
okay, heard Sri M. Khan, Learned Counsel for the petitioner. Full stop. It is the case of the petitioner. No, this is on the aspect of inquiry report, Ramjan Khan.
No, it is not. My lord, regarding my lord, 90 days, my lord, period. My lord, he, my.
That we are not saying anything now.
Reinstatement and.
No, we're not saying anything now. The petitioner claims to have been working as Lat Mandal in the office, in the circle office of the Gohapur Revenue Circle, Biswanath, and was arrested under the PC Act, Prevention of Corruption Act, on 7/8/2023. Full stop. On such arrest, comma, an order was passed on 8/8/2023, suspending the petitioner. Where is that order?
Well, suspension order is page 25.
But it's under the provisions of Rule 6(2) of the Assam Services within bracket Discipline and Appeal Service bracket close Rules 1964. The petitioner was granted bail and had thereafter submitted an application for his reinstatement. Full stop. In the meantime, comma, an inquiry was, a disciplinary proceeding was initiated, and the inquiry officer had also submitted inquiry report of 15/3/2024. Full stop. The disciplinary authority has, however, violated the impugned order dated 3/11/2023, has taken a decision for a de novo inquiry. Full stop.
36, 2024.
Oh,
306.
page
48.
Oh, okay, yes, not 3/11. It's 36/2024. Full stop. It is submitted that de novo inquiry is not permissible in law, and the learned counsel for the petitioner has also cited certain case laws. Full stop. Para. Sri J. Hendik, learned counsel, learned standing counsel, Revenue Department has, however, submitted that after promulgation of the Assam Land Records Subordinate Service Rules 2023, comma, a notification was issued on 3/11/2023 regarding the appointing authority and appointing authority, comma, disciplinary authority and appellate authority. And it is because of such notification, comma, the impugned order has been passed. Full stop. A perusal of the impugned order, however, does not reflect such consideration. Full stop. Para. Let notice be issued returnable by 6 weeks Three. Mr. Handy. For
For 1 and 2, Lordship.
1 and 2, TC Chutti addition city government 3 and 4. Extra copies within 3 working days. Para. Sri Khan, the learned counsel for the petition, appraised for an interim order. Full stop. Considering the settled position of law on this aspect, on the aspect of appointment of a de novo inquiry, comma, till the returnable date, comma, further proceedings, if any, of the de novo inquiry, as per the order dated 30/6/2024, shall remain suspended. Full stop. The matter may be listed on, since interim order will give a date. 1, 2, 3, 4. On 21st of August, on 19th of August.
19.
19.
This matter relates to payment of family pension, my lord. After death of the husband of the petitioner, he applied for pension, but the pension proposal has been returned back.
Parashar for which, whom?
My lord, this CRPF, my lord.
Oh, CGC.
My lord.
Yes, Lordship, is to notice. I'm not saying.
Heart 3 IH
1 to 5, my lord.
learned counsel for the petitioner, who is aggrieved by non-payment of family pension, full stop. It is contended that the deceased husband of the petitioner was working as a rifleman GD in the CRPF, who, however, was imposed with penalty of compulsory retirement on 12/10/1993. You're the second wife or first wife?
Second wife.
The allegation on which such penalty was imposed was on the ground that the petitioner had married for a second time without a divorce from the first wife. Full stop. The present petitioner claims to be the second wife. What is your right?
Under Rule 54(7)(1), the pension can be
But what is your right? You are not the wife at all.
First wife was.
It's not a question of first wife, second wife. If the parties were Mohammedan by religion, matter would have been slightly different. Parties are Hindus. There is no question of second wife.
Initially, there is a divorce by the Panchayat head in the year 1983.
Panchayat, can it pass any divorce?
So
that has been taken into aspect. There is no valid divorce.
By the family court also, there is a divorce.
Family court?
1994, my lord.
94.
Before that, my lord, the impugned order was passed by awarding punishment.
Last of ki kolo. Petitioner, husband of the petitioner. A valid first wife. Full stop. Sri Saikya has, however, clarified that after passing of the order of penalty, comma, a family court has granted divorce. Full stop. Para. Let notice be issued, returnable by 6 weeks. Sri K.K. Parashar learned standing learned CGC accepts notice on behalf of respondent number 125 TO2. Extra copies within 3 working days. Let steps be taken for service of notice
upon the response number 6 by registered post with AD.
After 4 weeks.
Give us 6 weeks.
62.
The husband had worked where? Here, last year?
Last year.
No, where did he work? In Assam?
In
But because the response number 6 is at UP. R6 is at UP.
they are residing in Nagawa, Assam.
Order is passed for PIC group center state plus 1.
The petitioner participated in the advertisement in 2017 and was cleared fourth round of written test and was called for interview for the post of assistant professor electrical engineering in the category of STP.
Before going to the issue, just point out that this matter is relating to assistant professor of engineering institute education department matter. So this is taking up next team matter. So I'm just pointing out. Otherwise, I have no objection.
No. Let it go before the appropriate bench. It appears that this matter pertains to civil bench 2. Para, list before the appropriate bench.
I may just point out that on an earlier occasion it was listed, similar matters were listed before bench.
Yes, Mr. Sharma, what is this?
Your Lordship,
IA for implement
implement, Your Lordship,
of
the opposite party number 1, Your Lordship, the Commissioner of Food, Civil Supplies, Consumer Affairs and Legal Metrology. The reason being, Your Lordship, on the first day when notices were issued, Your Lordship will kindly come to page 24. Page 24.
24.
24, Your Lordship. The last paragraph. Notice be issued to the respondents number 9 to 24 to the Director of Food, Civil Supplies and Consumer Affairs. That department, Your Lordship, has been merged with the Department of Controller of Legal Metrology. And now, Your Lordship, there is a commissionerate. And the powers are, Your Lordship, are vested on the Additional Commissioner of Food, Civil Supplies. The pursuant to that, you have made the change, Your Lordship, so that the notices can be issued at the private response. Notices are still not complete. The service is still not complete. The private response.
Yes.
I have no objection.
The commissioner actually taken necessary steps of giving the copy. That has already been done. I have the instruction, but first commissioner has to be made a party, then. So let it be.
Heard Sri M. Sharma, learned counsel for the applicants, writ petitioners who by means of this application has prayed for implement of the Commissioner, Food and Civil Supplies, Food, Civil Supplies, Consumer Affairs and Legal Metrology, Assam, as respondent number 24 in the connected 25 in the connected WPC 4331 of 2023. Full stop. It is submitted that such implement is required in the interest of justice and also for the purpose to ensure service upon the respondent, private respondents, which was indicated by this court in the order dated 4/8/2023. Full stop. Also heard 3 S. Bora, learned for
for PTC. So
For
in the
BTC.
I have not been made party, but
Learned, as per Learned Standing Council, BTC and Sri C.S. Hazarika Learned State Council, who do not raise serious objections to such prayer for implement, full stop, para, after considering the facts and circumstances, comma, the implement as sought for of the so-and-so, is allowed, who is to be implemented as party respondent number 25. Full stop. I accordingly stands allowed. In the writ petition you write, an order has been passed today, that is so-and-so, in IA number so-and-so, whereby the following incumbent is implemented as respondent number 25. তলত লিখি দিবা হা কমিশনাৰ সবখিনি একদম এটা লাইনতে লিখিবা এনেকে নাম্বাৰ যেনেকে লিখে কষ্ট টাইটেল the petitioners, the learned counsel for the petitioners is accordingly required to file amended cost title, which is to be done within a period of a week from today. Since the newly implemented respondent number 25 is the newly implemented respondent number 25 notice for the newly implemented respondent number 25 is accepted by Sri Hazarika, the Learned State Council. Full stop. The Sri Sharma, the Learned Counsel for the writ petitioners would serve an extra copy of the writ petition after amending the cost title.
great.
Yes.
My lord, the petitioner's elder brother Mirjan Ali, who worked in the department of the respondent 220 days, but he have not, after he was died in his harness, but he was not.
You have filed affidavit in opposition. Yes, what is your stand?
It is not admitted for ecclesia myself because the total work is 20 days. As per other time, that is a brief history of it. And my support document annex.
To be entitled for ex gratia, how many days have to perform?
That's required. Here, my lord, what happened in kindly see page number 31.
3-1.
31.
Yes.
Here, my lord, kindly see date of appointment is 29/1/2021 in the middle part.
Middle part.
It's the date of appointment. Clause 6. Last spell.
Yes. Date of appointment.
Date of appointment 29/1/2021. After that, my lord, he left the job. Again, he joined, that is case number 32.
Page 32.
Case 30. Here, case work, he left the job. And again, he joined on 16 September 2021.
16/9.
16/9/2021.
Thereafter,
He expired on 18/10.
18?
18/10/2021.
1810.
Yes.
For ex gratia,
Ex gratia, my lord, kindly see the page number 16. They have annexed that ex gratia, notification of ex gratia.
16.
16.
Yes.
In the second paragraph.
Yes.
Not second paragraph, first mile.
Yes. This is dated what, 14th January.
14 January 2009.
Yes.
at least for a total period of 179 days in service of year.
But when did he leave the job after being appointed on 29/1/2021?
16 September, and kindly see my lord, page number 15, my lord.
No,
it-
first you say that he was appointed on 29/1/2021, right?
Yes, my lord.
Thereafter, when did he leave the job?
He left as a pilot, that is by public. After 166 days, he left as job pilot.
Up to second,
Yes.
20th of July.
Yes.
20th of July, 21. Then 29th, 16/9 to 10/9. So if you calculate how many days?
Only 27 days, my lord.
Why 27 days?
My lord.
29/1 to 27/2021.
Yes, my lord. And he expired on
Then again 16/9 to 18/10.
18/10/2021.
Yes.
16 September 2000, September, October, my lord.
No, what about the first period? 29/1 to 20.
After that, my lord, he left the job, my lord. That is casual work. There is not required to termination and automatically terminated.
Yes.
And kindly see
This
one.
requirement of 179 days
Yes,
is to be on the date of
Of
that
that-
continuous service,
continuous, sir.
not with break.
Not with break, 179 days. And kindly see page number 50. Their affidavit, their petition, with petition.
Yes,
That is the police report.
yes,
As per police report in second line, the code number is 12357.
yes.
And 12357, my lord, that is in page number 38. Page number 38, my lord, as per 12357 code number, that his date of joining is September 2021.
Oh, that means the initial period of 29/1 to 29/1/2021 to 27/2021 will not have any meaning.
No, not meaningful.
If that was in that period, then matter would have been different.
Yes, sir. Because his date of appointment is 16 September 2020.
Let us read the page 16.
Yes.
16 again, right to convey the present.
Page 16, my lord.
In the worksite balance. Who have worked for at least.
And he already left.
Yes, what do you say? What do you say?
Page 40, he already received, my lord, under ECA, 816 lakhs.
Page 40. Oh, he has received something.
Page number 40, 16 lakhs. Page number 40,
1/4
405.
of your affidavit.
Yes. Employment Compensation Act 2023, he received that.
Yes, what do you say?
In Page number 16.
Yes.
In the first para, the middle, the case paid labor will have worked at least one for a total of 170 days. There is no any word of continuous. Who work at least 179 days.
Now, as on the date of the accident, suppose you worked for 179 days, then you had left. Suppose in a given case, you work for 200 days, then you left. Thereafter, you meet with an accident. Can you make a claim that I had worked for more than 179 days? As on the date of accident, it has been construed because we are on that which you are trying to say. Will a break in service can also be held to be entitled under 179 days? Notification does not appear to be in that direction.
In page 16, there is no any provision that he should be continuously work.
No, that is exactly what we had pointed it out. As on the date of the accident.
The deceased work at least 220 days in the same department. And at the time of his deployment of duties, he was died. Not at home. And it is proved by the MSCT accident case. It is proved that he was in duty, as they have admitted.
No, that is not the dispute at all. They are not denying that you died while on duty, but your entitlement to ex gratia, you have to meet the requirement of having completed 179 days as on the date of the death. If you calculate, you wanted to calculate a period after which there was a break, you had left, you had again joined. If the expression as on the date of death was not there, perhaps.
That is why our point is that there is any provision that he should be continuous in work.
Okay, we'll consider.
At least 170 days. That is written in para number 2.
Okay, what is your name?
Casual pay.
Yes, we'll consider. Yes. Heard through H.B. Learned Counsel for the petitioner. Also heard Ms. A. Gayan, Learned CZC. Full stop. The issue is with regard to a claim for ex gratia payment. Full stop. Para. Please have your seat. Please have your seat. The facts projected in the petition is that the brother of the petitioner, Mirzan Ali, was working as a master role worker with the Border Roads Development Board and had joined his service on 29/1/2021. Full stop. On 18/10/2021, he was deployed as a helper to in an excavator, and in an accident, he had sustained injuries, as a result of which he had passed away. Full stop. The petitioner has projected that as per the requirement of the notification holding the field on the issue of ex gratia payment, a minimum of 179 days of service is required, and the deceased brother of the petitioner had fulfilled such requirement. Full stop. The Learned Counsel accordingly submits that since the amount has not been paid, appropriate directions are required to be issued for payment and release of such ex gratia amount. Full stop. Para. Contesting the writ petition, Ms. Gayan, the Learned CZC, has submitted that the facts projected in the petition are not fully correct. Full stop. She clarifies that while the deceased brother had joined initially on 29/1/2021, he had left the job on 27/2021. Full stop. The deceased had thereafter was thereafter again engaged on 16/9/2021, and the accident had occurred on 18/10/2021. Full stop. By referring to the notification dated 14/1/2009 on the aspect of ex gratia payment, the learned CGC has submitted that 179 days in service as on the date of the accident is the condition precedent, and in this case the deceased did not fulfill the said condition. Full stop. The CGC has also informed this court that on the death of the brother of the petitioner, an amount of more than 16 lakhs has been paid by the workman, by the commissioner, workman compensation, employees compensation. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. While the contention of the petitioner is that the deceased has served more than 179 days by treating the initial date of appointment as 29/1/2021, the contention of the respondents is that such condition has to be fulfilled from the date of the accident. Full stop. Para. Though the deceased brother of the petitioner was initially engaged as a masteral worker on 29/1/2021, the deceased brother had left the job on 27/2021. Full stop. The aforesaid fact, which has been stated in the affidavit in opposition filed on 17/8/2023, has not been denied. Full stop. It is also not the case of the petitioner that the accident had taken place during the aforesaid period of employment. Full stop. The deceased brother was again engaged on 16/9/2021, and he passed away in the accident on 18/10/2021. Full stop. While the death of an employee is one of the condition precedent to claim ex gratia, the same is also qualified by the aspect that such employee need to serve at least 179 days. Full stop. The notification dated 14/1/2009 has clarified that such completion of 179 days has to be on the date of the accident leading to the death. Full stop. Though certain contention has been made, though a contention has been made that the total length of service is to be reckoned, the language employed in the notification would not lead this court to come to that conclusion. Full stop. The use of the expression within inverted comma, add on the date of the accident leading to the deaths would bring this court to the only conclusion that such 179 days have to be reckoned and calculated from the said date. Full stop. This court has also contemplated a situation where an employee who was engaged and had worked for more than 179 days and had thereafter discontinued meets with an accident. Full stop. In such case, comma, a claim for ex gratia would not be permissible, as the accident leading to the death has to be on the date when the employee was still in service. Full stop. Para. This court has also noted that the family, bereaved family, was not left without any assistance, and the respondents have put on record that an amount of more than 16 lakhs has been paid by the workman, by the commissioner, employees compensation. Full stop. Para. In view of the above, comma, this court is of the opinion that no relief can be granted to the petitioner in this case, and accordingly, the writ petition is dismissed. Yes.
Accepted.
May please, Lord. My Lord, the issues involved in this type of writ petition, my Lord, went to the Honorable Division Bench, my Lord. Division Bench heard the matter and a judgment is reserved. So today, may I pray that the matter may come after 2 weeks?
What is the issue?
My Lord, issue relates to termination of contractual employees.
Okay.
Whether, my lord, this
Okay,
stigmatic or not.
Okay. The learned counsel for the parties
Yes, sir.
have jointly submitted that the issue was before the Honorable Division Bench, in which the hearing is complete and the judgment is reserved. Full stop. Para. In that view of the in that view of the aforesaid submission, comma, these matters are adjourned by a month.
Right.
Full stop. Any developments? This court for a month to enable the learned counsel to apprise this court of the decision of the Honorable Division Bench.
Sir, item 36, 37, 38, which is joint pair, that also may be adjourned.
Maybe
That issue is not before the Division Bench, my Lord, but today, my Lord, I am paying for time.
36, 37 and 38.
36, 37, 38.
It would obviously 35 ole kya I go to. Then 36, 37. On a joint request, matters are adjourned to be listed after 2 weeks.
Mile.
Have you filed affidavit?
Not yet.
After 3 weeks, put stop. The PNRD department, represented by Sri S. Datta, the standing counsel, may file affidavit in opposition.
Yes, Lord.
Yes.
Item 39.
Instructions are awaited here.
That's a heavily pension matter.
Okay, get the instructions. No, very full. On the prayer of Sri C.S. Hazarika, learned State Council, matter is adjourned by further 3 weeks to enable obtaining of instructions. Full stop. Para. As the matter relates to family pension.
Family pension.
Matter may be list this case on 16th of August. Hurry up with the instructions. Yes. 40 PNB. Oh. A prayer for adjournment was made by the petitioner appearing in person to file rejoinder affidavit. Full stop. List. We fix a date. He is appearing in person. Now he is missing. List on. No, then I can elect him. A prayer for adjournment was made by the petitioner in person at the mentioning hours. Full stop. However, such mention being made in absence without information to the learned counsel for the respondent bank, comma, the request was declined. Full stop. Para. When the matter is called upon in its usual course, comma, the petitioner in person is absent, whereas Sri Dhanuka, A. Dhanuka, learned counsel, is present for the respondent bank. Full stop. Para, be that as it may, comma, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit by the petitioner. Full stop. As the petitioner is appearing in person, comma, let a date be fixed. In this case, para, list on, accordingly list on 19th of, on 16th of August. 16 August. August.
Lordship kindly peruses the order dated 25/6/2024.
Yes.
25/6/2024.
Yes.
Fifth line from bottom.
Hmm.
Fifth line from bottom, my lord. The line starting from the GMC authorities.
Yes.
The GMC authorities
We have read it. Yes.
shall within
Yes,
20
we have read it. Yes.
Yes, Lordship. My order dated 27/6/2024, it has already been fixed at the rate of 45,086.
27/6. Yes, are you aware?
It says along with the payment, but the payment has not been received as of
Payment,
date.
order was made on 27/6, Lordship. This month you will get the provisional pay.
That will be recorded.
Okay, we'll record. Third, Sri A.K. Barua, learned counsel for the petitioner. Full stop. Para. Sri P. Nayak, learned standing counsel, Finance Department, submits that the pension amount,
Provisional pay.
provisional pension amount of rupees
45,086.
45,086 has been sanctioned.
Yes, Lord.
Has been sanctioned. Full stop. Sri Barua, learned counsel for the petitioner, however, informs this court that the amount is yet to be received. Full stop. Para. Considering the above, considering that the amount has been sanctioned, comma, matter is adjourned by 3 weeks to enable the onward steps to be taken. Full stop. Both the learned counsel may apprise this court of the development
And my lord,
about the progress on the next date.
that provisional pension is with effect from the date of my superannuation, my lord.
Let us see first. List on 16th of August.
Oblige.
B. Sharma, H. D. Bora, State Council. Yes.
Oblige.
42.
May I please, Your Lord?
Yes.
Today fixed for instruction.
He was suspended on regarding reinstatement. The instruction is silent, but I already advised the department matter to reinstate, and it's on.
You cannot keep under prolonged suspension if you have not initiated the
Direct
proceeding.
giving some time, my.
No, you instead him, you post her, him or her, lady or
Lady no.
post her in any non-sensitive post. And the order for reinstatement will not have any effect on your department proceeding.
Yes,
absolutely.
Yes, that can.
Okay, heard. Sri P.K. Deka, learned counsel for the কালি আমি এটা সাসপেনশনে মাৰিছিলো নহয় এই যে অজয় চৌধুৰী ৰাকিব উদ্দিন এইবিলাক কৈ were you arrested or was there any criminal case
No, my lord.
ওপৰতে লিখি দিম আৰু
Other,
oh Ajay also heard Sri S. Datta, learned standing counsel Panchayat and Rural Development Department. Para, please have your seat. If there is any requirement, we'll call. The issue raised is regarding the prolonged suspension of the petitioner from service. Full stop, para. It is the projected case that the petitioner was discharging his duties as secretary of the Huban Hill and Didar Kush Gao Panchayats wide and order dated 22/5/2023. नाम के side अब हाँ Huban Hill. Thereafter, comma, he was thereafter wide and order dated 8/1/2024, comma, his duties were restricted to Bhuban Hill Gaon Panchayat, full stop. Wide the impugned order dated 25/2/2024, comma, the petitioner was placed under suspension, full stop. It is the specific case of the petitioner that there was no periodic review of the order of suspension. Until date, no departmental proceeding has been initiated.
And memorandum has also not been started.
That is department proceeding initiated, full stop. Para, Sri Deka, the learned counsel for the petitioner, has relied upon the case of Ajay Chaudhary versus Union of India, in which it has been laid down that timely review within a period of 90 days is a mandatory requirement if the charge memo is not furnished in the meantime. Full stop, para. This court had directed the learned standing counsel of the department to obtain specific instructions. Full stop. Sri Datta, the learned standing counsel, has placed before this court a written communication dated 26/7/2024 on the aspect of withdrawal of departmental proceeding, full stop. As per the said instructions, comma, no such proceeding has been initiated and no memorandum of charge could be served upon the petitioner till date, full stop, para. In view of the authoritative pronouncement by the Honorable Supreme Court in a catena of judgments, including the case of Ajay Chaudhary Supra, comma, this court is left with no other option but to direct reinstatement on the ground that an employee cannot be put under prolonged suspension without initiation of a departmental proceeding and without having periodic review to come to a satisfaction that such suspension is required to be extended. Full stop, para. Accordingly, comma, the writ petition is allowed by directing reinstatement of the petitioner. Full stop. However, it is provided that the respondents would be at liberty to post the petitioner in any non-sensitive post by which the contemplated departmental proceeding may not be affected. Full stop. The present order of reinstatement would not have any effect whatsoever in the contemplated disciplinary proceeding if held in accordance with law.
My lord, reinstatement method.
Immediately.
Time, my lord.
Immediately.
Immediately.
Some time, my lord, 10 days maybe.
Some time maybe.
What sometime? You do it immediately. Uh, the orders, the posting, reinstatement, the orders of posting of the petitioner pursuant to the order passed today of reinstatement may be passed within a period of 15 days from today.
My lord, deeply obliged. Obliged.
43.
May I please?
Yes.
Lord, this case, my learned friend has filed a affidavit today. I find that the certain for facts are incorrect, so it needs to be
Rejoinder affidavit.
No, Lord, we have filed reply. Reply.
Rejoinder affidavit.
Rejoinder affidavit. So, my Lord, I have the documents to controvert that, but I think I must produce
You
that.
produce the
I have an
documents.
affidavit.
No need of affidavit.
Lord, if that's
No
better.
need. We'll have it for admission hearing.
Lord,
Has it been admitted? What is the matter?
seniority list, Lord.
If it is the case, the clear case, their own guidelines, whereby it was provided that the employee who were transferred from the other report, the separate seniority list will be maintained.
Okay.
But in
Pleadings are complete and the matter can be taken up for admission hearing. Full stop. When?
next week, because
List for admission hearing.
today is before
On,
the intent consideration.
on Friday next.
Friday.
Next Friday.
Tuesday, Lord, Tuesday or any Tuesday.
No, not Tuesday, Thursday. We have to give preference to whole matters. These are new matters.
Obliged.
Well, in this matter, the state has filed the affidavit in opposition. Some subsequent development has taken place. So I have to file a reply.
Okay. On the prayer of Heart Free R Islam Learned Council for the petitioner. Whereas Sri K.P. Pathak Learned Standing Council, Excise Department is present. Para, on the prayer of Sri Islam, the Learned Council, 3 weeks time is granted. 2 weeks time is granted to file rejoinder affidavit.
Master.
Yes.
Wait, doctor. In this case, the petitioner is
Excise Department.
Yes, ma'am.
Affidavits are exchanged. You have filed rejoinder. Yes. What is it?
By the impugned order at page 24, my lord, the petitioner has been transferred.
Transfer matter.
Yes, ma'am.
The private respondent has joined you.
Yes, ma'am. But
Grounds.
pursuant to your
Grounds.
Ground is, my lord, last transfer was issued on 12th of February 2024. Again, he has been, my lord, transferred by the impugned order at page, my lord, 24 on 6/6/2020.
Frequent transfer.
Frequent transfer. In violation of the policy.
Grounds that we have taken, our response on affidavit is that earlier transfer in February was pursuant to the directions of the Election Commission.
Okay.
Because nobody can serve in his home district. But even otherwise, the policy regarding frequent transfer does not cover the post in which the petitioner is serving. There is the Department of Personnel which has issued the policy. It has specifically clarified that these posts are not.
What is the post involved?
Assistant Inspector of Excise.
Not covered.
Not covered. So, and the public interest on which this entire reshuffle, not only him.
Mr. Sekia, transfer from where to where?
My lord, I have been transferred from Thekiasduli to, my lord, Hodia.
To Hodia?
My lord. And only to accommodate the private respondent, my lord. He was earlier, my lord.
Who is for the private respondent? Served or not?
My lord, notice has not been issued.
Notice not issued? How is it possible? This has not been, there is no notice issued here.
Lordship, actually, on the last stage, after exchange of pleading, before the petitioner in fact filed the rejoinder,
No, notice has been issued
yes,
on 24/6.
yes.
On 24/6, actually, my lord, the honorable court, my lord, was of the opinion that order will pass in this chamber.
Yes, order was reserved. That is
No, I think it's keep the attention of the court, learned brother, because see, there is an express mention of notice being issued, but only Mr. The requisite extra copies of the petition will start on the standing counsel within 2 days. Perhaps the aspect of private respondent has escaped the notice. You take steps generally in absence of whether we allow or dismiss. If we
In that
dismiss,
case-
there is no problem. If
in
we
that
allow,
case-
we have to give an hearing.
In that case, my lord, just to be permit trustee also, my lord, because, my lord, otherwise,
Okay.
notice will not be served.
Okay. এটা order to pass করে দাও। Heard 3, I.H. Saikia, learned counsel for the petitioner, whereas Sri K.P. Pathak, learned standing counsel, is present for the excise department.
Respond numbers 1, 2, 3, and
Excise department. It appears from the order dated 24/6/2024 that while issuing notice, steps for service of notice upon the private respondent number 5 was not directed to be taken. Full stop para. Let steps for service of notice upon the respondent number 5 be taken by registered post with AD within 3 working days. Full stop para. The learned counsel for the petitioner prays for a liberty to cause dusty service upon the said respondent number 5. Dusty service is allowed, is permitted to be taken, which however is to be routed through the registry of this court. Full stop. In the notice accompanying the dusty service, the next date is to be specifically mentioned. Full stop. The next date is accordingly fixed on. On 14th of August, 2024, prior to his date, the petitioner is required to file an affidavit in proof of such justice service.
Well, item 63 is also similar issue, my lord, item 63. But in that case, my lord,
Now, level at 2 o'clock.
my lord, trustee will take the matter on 14th along with this petition. Because, my lord, same issue, my lord, same transfer order, my lord.
Same incumbent.
Same, my lord, other incumbent, but same transfer order and the, my lord, on the.
Notice is served.
order is the same. That
Same order.
Yes, item 44 is the private respondent, my lord, in item 63.
person who had the previous matter, your lordship.
In this case, my lord, both the private respondent and the
Both of them are
petitioner,
aggrieved,
where
my
both
lord,
of them aggrieved and filed. In 44, my lord, I am the private respondent number in item number 46.
Item number?
Item number 63, in item number 63, my lord, the petitioner in item number 44 is a private respondent, my lord.
Notice is yet to be issued.
Notice has been issued, same order was passed, my lord, but my lord, my friend will appear for the private respondent and I will appear in his case, my lord. So, my lord,
63.
my lord, if your lordship takes both the petitions together.
No, that dusty part we can remove, but we do not know whether the.
Not in that matter. your
Lordship may observe that I will receive the.
No, that is okay. In 63, what order should he pass?
My friend received the notice for the respondent number 5 and lordship fixed the matter on 14th, my lord, along with the other.
Perhaps
petitions.
Kaladnama will have to be filed, your lordship, in that matter.
63, you write, list along with WPC. I go to, 3050.
3050 and my lord.
No.
3023, my.
3023.
23.
No, what was the order just we had passed?
Lordship, in that matter, the private respondent is a third party, who is not before your lordship. So perhaps justice will have to be taken, your lordship.
In 63.
In
45, I will take that estimate.
No, no, what was the order? We passed in orders in which case right
in item
now?
number 45, your lordship has passed an order for justice service.
45.
Yes, that person is not before your lord.
Oh, no, 45 is gone. Now which matter are trying to?
63.
Well,
63. We
63
said
and
63 will be
44.
enough.
Yes,
And 44.
44 and 63 can be taken up together.
Then that notice part will cover.
44 and 63.
Yes.
madam.
Then in 63, you write list along with WPC 3023 of 2024. Parties may exchange, parties may file their appearance in the meantime.
And that time we fix on 14th, my lord.
On same date.
Same date.
No, but your case, did you fix a date?
No, not date, not fixed, well, after 2 weeks.
Then you have to write in 44 on request list on 14th
14th of August.
14th of August out of 64 likhiba 64 ne ki asile 63 list along with so and so on 14th. Huh? In the meantime, the appearance of the okay.
Mark.
This is a suspension matter. The petitioner was suspended, but no action was taken for his statement and nothing has been held. So, my lord, they took time, last time, as some process is on. Your lordship may direct the respondents to reinstate the petitioner as per the decision ruling of the Supreme Court.
Lordship, as per my telephonic instruction, 10 more days time may be required, Lordship. Complete the process.
Process means
Reinstatement, Lordship.
reinstatement.
Lordship.
You are contemplating to reinstate him.
Lordship.
Okay, then it's good. We record.
Lordship.
Heard Sri H.K. Mohanto, learned counsel for the petitioner. Ms. G. Bora, learned counsel representing the
Agriculture Department.
cooperation क्यों ली से दो बार?
1 to
Agriculture Department was granted time on the last occasion to obtain instructions. Full stop. The Standing Council has submitted, the London Standing Council has submitted that the process of reinstatement
Lordship.
of the petitioner, is it for reinstatement?
Lordship. Lordship.
Is going on and would be done within a period of 10 days, in a period of about 10 days. Full stop. Also heard Sri S.K. Medhi, learned Standing Council, AG Assam. We close this then. In view of the submissions made by the learned Standing Council of the department on instructions, comma, the petition is closed with a direction to comply, with a direction to complete the process for reinstatement within the stipulated period of about 10 days.
Hello.
Disposal.
Wait, please, your lordship. Lordship,
Just 10 minutes, but some instructions have come. Just it.
Or we'll have it on Wednesday next.
Yes.
Today we have to rise early because of reference. Monday may not be possible to Wednesday. What is the matter? Prolonged
subsequent
suspension.
review was not done.
Okay, on Wednesday.
Well,
Okay. Sri D. Gogoi, learned Standing Council for
PHE,
Department, PHE, submits that instructions would be received during the course of the day. Full stop. Para. Considering the above, matter is adjourned to be listed on Wednesday. Date.
May I please, Lord? Lord, the cancel matter.
Transfer.
Transfer matter. So petitioner before your lordship is a member of RPF who was transferred along with some other person on 21/7/2023.
Yes, file affidavit. Wednesday we'll have it. Okay. While Sri I. Rafiq, learned counsel for the petitioner is present, comma, a prayer for adjournment has been made on behalf of Sri M. R. Odhikari, learned CGC, who is entrusted with this case. Full stop para.
On Friday, Miller. On
Oh.
Wednesday, I'll not say.
On request, list on Friday next.
Right.
48, 49, same matter. We have not given any instruction. In 49, I have clear cut it. No instruction has been given. Therefore, 2 weeks time may be granted.
No, don't. A prayer for adjournment has been made on behalf of Sri M. R. Odhikari, learned CGC. Full stop para. This court has also been informed that instructions are yet to be received. Accordingly, list this case after 2 weeks. We'll fix on Friday, not this Friday, next Friday.
Next Friday.
On today is 26th, isn't it? We'll fix on 9th.
Yes, sir.
9th, 9th. And in the next matter, don't write MR Odhikari here.
Same matter.
Same matter.
No, you are appearing here.
Yes,
While Sri so-and-so is appearing, Miss RDB, London CGC, praise for, huh? MR Odhikari ka nahi aayega. That instruction not received, so 2 weeks. Friday.
Take this.
49 में MR Odhikari ka nahi aayega. समझ रहे? Yes.
Matter pertains to appointment.
Matter number 50. Contempt.
Yes, sir. Second day is for even answer.
Unserved.
Yes.
Address and addressee left, RTS. Who's the respondent?
Commissioner, Central Assam Division.
Commissioner,
Central Assam.
maybe there is some change in incumbent.
Yes, sir.
When did you file it? This is a recent filing.
Yes, sir.
You take instructions. Office note dated 27/7/2024 reflects that the sole respondent could not be served as the addressee has left. Full stop. Para. Sri Bora, the learned counsel for the petitioner, prays for and is granted 2 weeks' time to obtain instructions in this regard.
Public.
We have filed affidavit in opposition method, but that is not in the record. Yesterday we filed. So.
Yes.
So, it may be come up under one after 1 week.
Next week, my lord, such
Tell us when.
next week, my lord, any time.
I is for what?
I have for vacating the interim.
Forward.
Okay. Okay, Wednesday next. In this IA, comma, the opposite party writ petitioner has filed affidavit in opposition. Full stop. List for consideration on Wednesday next. Record KK Fukan and AK Datta. KK Fukan for applicant writ petitioner, KK Datta, AK Datta, learned CGC. CGC or LGBI? Which one?
Hello?
You have standing counsel, CGC or what?
CGC and standing council
Of?
LGB.
LGB. Standing council? Local governor LGB जो है ना. Yes.
My lord, the matter, my lord, the file, my lord, to withdraw the benefits of retention of top accommodation.
Hmm?
My lord, to withdraw the benefits of retention of top accommodation in the last place of. So, my lord, this honorable passed an order, my lord, on 9/4/2024.
I for what?
I, my lord, petitioner file, my lord, what happened, my lord, respondent number 2, my lord, time to time, my lord, for my lord, the notification for the retention, my lord, to who, my lord, the officers posted in the Northeast statement.
Okay.
Since my lord, Northeast is a non-family station. The last month of notification was issued, my lord, that is, my lord, 8/4/2021. It is, my lord, page 84, my lord, read petition, my lord. So, my lord, that was, my lord, up to 30 June 2024.
Yes, sir. What is the
Lordship, similar matters have been fixed on 5th.
August?
Yes, it may be taken up on 5th together.
Okay, no. We'll have it on 5th.
Lord.
It is submitted that certain similar matters, including WBC
9/25 of 20.
9/25 of 2023, are fixed on 5/8/2024. Para, list this case along with those cases on 5/8/2024.
Obliged. My lord, there is an interim order, my lord.
Interim order passed earlier to continue till the next date of listing.
My lord, in the meantime, my lord, the respondent file affidavit, my lord.
Lordship, in another case I have filed that will.
Lord.
I've given him.
Obliged.
Item 64, something is.
On the last occasion, my lord, the instruction was sought for, my lord, on the strength of my affidavit, my lord, additional affidavit, which I have filed, my lord, brought into record, my lord. Though they state in the affidavit, no promotion has been initiated, my lord, but some of them promotion has been given, my lord, and I have annexed in the additional affidavit which I have filed later. That instruction was sought to clarify the stand.
Yes.
Over rational just on method. My lord, that the allegation that the Gopesh Pathak, the peon, was promoted to a junior assistant post, lordship. And the petitioner who was supposed to promoted to statistical office post, lordship.
Any grade 3.
Lordship, but a statistical field assistant post. The field assistant post is still vacant, lordship. Firstly, that he was a master worker, and then he was promoted to grade 4, which was a supernumerary post. That's the first criteria, and second criteria is that as per the Assam Gazette, lordship, the field assistant, the requisite qualification for the field assistant, statistical assistant, field assistant statistics, he should be qualified with in HSLC with a pass mark of 50%, which this petitioner is not
Having.
qualified. There's two criteria. These are the two criteria instructions, lordship, of the department.
How do you react to this?
My lord, let them file affidavit, my lord.
On this point?
On this point.
That was not taken up in the earlier.
No, my lord. It was not been so far, my lord. My knowledge concerned, my lord. It is not so that, my lord. 50% or 60%.
Okay.
Let them file affidavit, court affidavit, my
In
lord.
terms of the earlier order, in this case, affidavits have been exchanged. Para. This court, however, on 18/7/2024, had granted time to Ms. M. Kotoki, Learned Standing Council, H and Veterinary Department, to obtain instructions on certain issues taken up by the petitioner in the subsequent affidavit filed. Ms. Kotoki, the Learned Standing Council, has submitted on instructions that there are certain relevant issues to defend the action, which, however, has not been placed on record. Full stop.
let a short affidavit, let an additional affidavit be filed by the department on covering those aspects so that the petitioner gets a fair chance. Full stop para. How soon? 2 weeks? Let such affidavit be filed within a period of 2 weeks. from
Date
today.
may be fixed, my lord, any
List,
day.
list on, we'll have it on 14th of August.
Okay. My lord, my concern is only, not only my lord, sectional assistant, any kind of grade 3 my lord. Though I made a prayer, sectional assistant.
Okay. Mr. Chaudhary, which matter?
Reference of